So the federal prohibition on nonviolent felons possessing and having firearms is once again under review after the Supreme Court's recent 8-1 decision in GVR. So let's break down what is happening. Now, real quick before we jump into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm is an amazing company. They have amazing supplements, and they believe in freedom and the Second Amendment. I spent a lot of time with the guys over there at 1st Phorm. They're amazing people, and they just want to support the community here. So if you guys are interested, check them out using the links down below. Again, amazing supplements, and they are pro-freedom. Now, as I mentioned in the intro, in this video, we're going to be discussing a huge Second Amendment case that the Supreme Court recently granted, vacated, and remanded after they issued their 8-1 decision in the Rahimi case. The case we're going to be discussing in this video is called Range versus Garland, and we've talked about it before, and it involves a challenge to the federal laws which prohibit someone with a nonviolent felony or misdemeanor equivalent from being able to own, possess, or acquire firearms. This case, Range, has become even more important in light of the Supreme Court issuing that recent 8-1 decision in the Rahimi case. Now, in the Rahimi case, the Supreme Court upheld the federal law which restricts the possession of firearms for someone who is subject to a domestic violence restraining order. And now, after that Rahimi case and that decision by the Supreme Court, the court decided to send the Range case back down to the Third Circuit en banc panel for a new analysis in light of what they said in Rahimi. And now we have the first arguments in the Range case in front of the en banc panel, and they are using the new Rahimi decision, so it's one of the first times that we're seeing this play out. Now, for those not aware, the Range case involves an issue of an individual losing his two-way rights under the federal law essentially forever because of one incident. 26 years ago, Brian Range, the plaintiff here, was convicted of concealing some of his income so that he could obtain additional food stamps for his family. Essentially, he simply made a false statement on a government form. He lied about some of his income, and because of that one Class 1 misdemeanor in the state of Pennsylvania, he is essentially restricted forever from being able to exercise his two-way rights. Mr. Range brought this lawsuit originally before a federal district court in Pennsylvania against the Attorney General and the ATF. However, the federal district court on review ruled in favor of the federal government on a motion for summary judgment. And in doing that, the court used what is known as the two-step approach. Now, you may recall that we've talked about how the two-step approach and the balancing of interest approach has now, been struck down by the Supreme Court in the 6-3 decision in the New York State Rifle and Pistol Association versus Bruen case. Now, after losing at the district court level, Mr. Range then appealed up to the Third Circuit. And on review, a 3-judge panel in the Third Circuit issued an opinion essentially upholding what the lower court said. Now, in that decision, the lower court there, the 3-judge panel, still used the Bruen analysis. They cited history and tradition as a rationale for these types of restrictions. Now, one of the interesting things here is, again, they did use Bruen, but they said Mr. Range was not a law-abiding responsible citizen. And since he's not a law-abiding responsible citizen, he's not one of the people as referenced in the text of the Second Amendment. Well, after that decision, Mr. Range did not quit, and he sought en banc panel review in the Third Circuit. And on review, an en banc panel in the Third Circuit found that section 922G1 as applied to him is in fact unconstitutional. Now, in that decision, the majority discussed how their precedent had prior been incorrect. They went on to say in their opinion that Range's appeal instead requires us to examine who is among the people protected by the Second Amendment. Range claims he is one of the people entitled to keep and bear arms, and that our nation has no historical tradition of disarming people like him. The government responded that Mr. Range has not been one of the people since 1995, when he pled guilty in Pennsylvania to that one false statement, essentially making false statements on that food application. And they claim that disarmament is historically supported. So here the Third Circuit nicely clarified what they were reviewing, and ultimately what they found is that Mr. Range is one of the people. This whole law-abiding responsible person analysis that the government wanted was improper. Mr. Range is one of the people, and he has the right to keep and bear arms. And based on that, the Third Circuit en banc panel struck down what the lower court's decision was and said that Mr. Range should have been granted a declaratory judgment in his favor, and he should be able to purchase and possess the type of firearms that he wants. Now, of course, the federal government did not like that, so then they filed a writ of cert to the Supreme Court. They went to the Supreme Court for a reversal of that decision. But the Supreme Court recently granted review to the Rahimi case, which deals with another section of the same federal law prohibiting individuals subject to domestic violence restraining orders, essentially also barring them from purchasing and possessing and having access to firearms while they're subject to those orders. The Supreme Court granted review to Rahimi, and ultimately what they did with the Range case is they put it on hold in light of what they were going to do in Rahimi. Now, as I mentioned, the Rahimi case was recently decided and it came out as an 8-1 decision. And ultimately what the Supreme Court found is that section 922G1, that section there, that was constitutional, at least in some applications, based on some of the facial challenges that were brought in the lower court. And because of that 8-1 decision in Rahimi, the Supreme Court then granted, vacated, and remanded this case Range back down to the Third Circuit en banc panel for a new analysis and a new decision in light of what they just did in Rahimi. Now, Mr. Range has filed his new brief in light of what happened in Rahimi, and the arguments are once again starting again in this Range case at the Third Circuit level. Mr. Range in his brief first argues that the rationale in Rahimi really should not change the outcome of this case at all. Mainly, he tries to essentially draw a distinction between the type of temporary disarmament that was involved directly in the Rahimi case versus the more permanent ban which is involved in his case, because Mr. Range is barred forever from purchasing, possessing, and using firearms. But in the Rahimi case, that was specifically more about temporary disarmament based on that situation there. In their brief, they argue that the Rahimi holding does not overlap with this case at all. Whereas Rahimi was temporarily disarmed after a court found he posed a threat of future violence, the government would disarm Range for life, having admitted he's not a danger to anyone, based only on a conviction for making false statements in an application for food stamps benefits. Therefore, just as before Rahimi, the burden remains on the government to show that the Second Amendment's text, as informed by history, supports permanent disarmament following a conviction wholly unrelated to violence or danger. They then go on to argue that the Rahimi rationale actually means that the prior decision in Range should in fact be reaffirmed. One of their reasons is because in Rahimi, the Supreme Court rejected the whole responsible person analysis, which is very similar to the law-abiding, citizen analysis that the federal government is putting forward in this Range case. They are very similar arguments. In Rahimi, they said, we are putting forward this argument that only responsible people have the right to keep and bear arms. And here in the Range case, they're saying only law-abiding citizens have access to the right to keep and bear arms. Similar arguments. The Supreme Court struck that down in Rahimi. And again, also the Third Circuit here should follow that and find that this whole responsible citizen or this law-abiding citizen analysis is just not appropriate. Also, the concept of being disarmed forever because of a nonviolent felony is not consistent with what the Supreme Court just said in Rahimi. Rahimi focused on temporary disarmament based on historical principles. However, Rahimi cannot be used to support Mr. Range being disarmed forever because of a single nonviolent misdemeanor. So those are the general takeaways of what was now argued in this case in light of what just happened in Rahimi. Like I mentioned, this Range case was granted, vacated, and remanded back down to the Third Circuit for a new analysis and a new decision in light of that decision. Now, if you were to ask my opinion of how I think the Third Circuit en banc panel is going to rule in this, I do not, think at all that they're going to change their decision. If anything, I think there's a lot of language in Rahimi that actually supports what they did before. But ultimately, I think this Range case is one of those cases that is very much destined to once again make its way back to the Supreme Court. I think the Third Circuit is going to move on this very fast. I think they're just going to say, hey, we got it right the first time. The Supreme Court in Rahimi didn't really change much. If anything, they just showed we got it right the first time, and they're going to issue their decision, I think, fairly fast. And then this is going to make its way back to the Supreme Court. So that's what's currently happening in this case. I know a lot of people had questions about what's going on with the Range case after it was GVR'd, and that's where it currently stands. If anything else changes, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.